the branch that in relation to volunteering. And then on the 3rd of May, we've got book group, and this month's book is Neuroscience for Leadership. I'm looking at it at my side here. It's bought but unopened. The 11th of May is a student event. It's a branch event that's a follow-on from the student conference. We were asked to do this by Wimbledon this year. So there's myself and two of my colleagues from RGU are going to be doing a sort of round robin of rooms for students on the 11th of May. 24th of May, you'll be fed up listening to my dulcet tones. I'm back talking about the benefits of membership. And then on the 15th of June, it's our annual meeting. That's going to be at Jury's Inn, just beside the train station. We've got Linda O'Donnell coming along, and she's using something I've never heard of. It's called Luminous Spark. So there'll be a bit of an activity as well as the annual meeting. All the details of all these events are on the website, and there'll be links there to Eventbrite for you to sign up. There will also be a Survey Monkey going out just after the event this afternoon. So it really does help us with our planning, and also to give some feedback to Lily. If you could take a couple of minutes to fill that out, and I think it's about 8 or 9 questions. It's not massive. If you could do that, we would really appreciate it. Lily and I were just chatting, and she's quite happy to take questions as she's going through her presentation. So if you want to pop questions into the chat box, I can manage them that way, and we can ask them at the time rather than keeping questions to the end. So let me just introduce Lily then. Lily is possibly well known to some of you in that she's supported the branch in the past, but she holds degrees in psychology and law and a postgraduate master's degree in employment law and practice. And she trained in mediation in 2006. She currently practices as a mediator, an employment law and business consultant in Aberdeen. During her time in a local private practice, she won the accolade of Rising Star of the Year in the 2004 Legal Awards. She then became a partner and headed up the employment law team within a large Aberdeen legal firm before breaking off to start her own practice in 2009. She's lectured at both Aberdeen University and RGU in the subjects of HR, mediation and employment law. And having listened to her in the past, I can tell you that she is fascinating to listen to. She's got some great stories. So without further ado, and no pressure, Lily, I'll hand over to you.
Yeah, and because I may know some of you, you might want to be generous. If you hear something that sounds familiar, it might be one of your old cases from 10 or 15 years ago. I'm going to try and screen share now. Hopefully that will.
Yeah, that's good.
You got that? Can I get it? There we go. We're going to presentation mode. So the topic for today is dispute resolution and mediation. And you'll see that in my title, I've changed the order of that because I am going to focus on mediation. I think you're all probably quite seasoned in various dispute resolution methods. We have any informal method is dispute resolution. Dispute resolution is just trying to sort things out. So the most common one that you're going to use is sit down with people and chat to them and find out what's going on. Dispute resolution can also take the form of discipline and grievance. Now, I have a bit of a different view on that. That's what it's meant to do. That's what we're told it's meant to do. In 23 years of being an employment lawyer in practice, I'm not so convinced that that's what it does in every case. So that's really what today is not about taking notes and me giving you lots of academic content. It's really about sitting down as a group of practitioners and talking about what works, what doesn't work, when things work in a particular way and when other things are more relevant or useful. So by no means am I saying that any of these other dispute resolution methods don't work. It's just that we tend to rely on the very formal ones more often than we should, and they don't necessarily help in certain circumstances. So discipline and grievance is fine in the appropriate circumstances. Mediation we'll be talking about today, and I do love getting people's views on what mediation is. I actually called a month ago to get my professional indemnity insurance renewed with the insurance company, and they said, so you do meditation and employment law? It's like, maybe I should do more meditation, but no, that's not on my list of activities. So I had to correct them. But you'd be surprised how many people think that I sit here in robes, cross-legged, trying to meditate through people's problems. But no, that's not what it is. Dispute resolution also includes litigation. So employment tribunals and courts are also dispute resolution methods as well. And obviously, in some cases, that's the most appropriate method. The final one is arbitration, which is not common at all in the workplace and employment law. It tends to be used a lot in construction disputes and commercial disputes. So there's no point really discussing that today because it's very, very rarely applicable. Okay, so what is mediation? And I thought, because there's so many different views people have of what it is and what it isn't, we'd start with the dictionary. So according to the Collins English Dictionary, mediation is the process of talking to two separate people or groups involved in a disagreement to help them agree or find a solution to their problems. Fair enough, that's a reasonable opening definition. Talking to two separate groups of people. Slight issue with that, because one of the first things you learn when you train as a mediator is you've got two of these and one of these, and you should use them in that proportion. The mediator is not there to do an awful lot of the talking, and that's where the skill lies. It's in being the silent ninja that helps people resolve their own issues and problems. It mentions a disagreement. Sometimes there is a disagreement, but I find in a lot of the cases I deal with, it's not so much a disagreement as a misalignment, where things start to go wrong in a work relationship and there's a dissonance that's created, and it's not necessarily an active problem that they can point to one thing and say, this is the issue. So disagreement, it's discord, I would say, rather than necessarily a disagreement. You're there to help them, which you are, not judge, not decide, not to cajole them into any particular solution, but to help them see what's right for them. And sometimes what's right for them is not being in the situation at all. And I'll get back to that. So the solution can be an agreement, but it actually can be a mutual parting of ways as well. And that's a successful mediation, because if the process of talking about the issue and looking at what all the various possibilities might be, sometimes the solution for that person that they come to happily is, I'm going to move on now. And that's okay. That's a success, because it does actually resolve the issue at hand. So what's mediation? Mediation can be something that you treat as informal. So I quite often get a phone call asking me to do a mediation, and the person will say, we've already mediated this ourselves. And I think, okay, I wonder what you mean by that. And normally what they mean by that is that they've had the informal sit down with them to try and resolve issues. Formal mediation, if any of you have undergone any of the training courses that are available, ACAS does training, there's the Mediation Partnership in Aberdeen that does training. I trained with Core Mediation in Edinburgh, I think they still do it. There's a whole bunch of places that you can go to get mediation training. And when you do that training, you understand that mediation is a skill. So not everyone's suited to it. Even if they've been through the course and passed it, I can tell you not everyone is actually suited to doing mediation. But there are also certain golden rules in being a mediator in a proper formal setting that when I hear about what do you mean by mediation, I find out they haven't actually done it as a mediation. It has been a sit down and a chat. So that doesn't mean it's not a mediation, it just means it's not in the formal sense a mediation. Then we've got what some of you might have experienced is a litigated mediation or a judicial mediation. So what I would call a litigated mediation is where you've actively got an employment tribunal that you're defending, and someone will suggest, let's have some mediation to see if we can resolve this before it goes to the tribunal. And I've acted in ones like this where you're called in as an independent third party. This to me is more of, I would call this a facilitated negotiation. It's called a mediation, but to my mind, it's not really a mediation because all we're trying to do is land on a number and withdrawal of the case. So it's missing a number of the elements of mediation in the workplace, as I would see it. The other kind is judicial mediation, where it's the same thing happening, but it's an employment judge who's been trained in mediation methods carrying out that litigated negotiation, assisted negotiation. And the most interesting mediators I've ever come across have been judges, because they're not mediating. They're really not mediating. They often get the thing settled and you arrive at a number and everybody walks away relieved that they don't have to go through the case. But to my mind, it's been an assisted negotiation. It hasn't been a true mediation. And then you've got the workplace mediation, and that tends to happen usually round about the grievance stage. So either somebody has made comments or suggestions that they're unhappy about something in the workplace, and HR will suggest mediation, or they sometimes suggest mediation, and sometimes an actual grievance has been raised or an actual grievance has been heard, and that's where it would take place in the workplace. When is mediation a good thing instead of a grievance, and when isn't it? So to my mind, if you're talking about legal rights, so if you think about a few years ago when there was a big hoo-ha with all the unions about whether the working time regulations meant that you could treat field breaks for offshore folk as holidays, or whether they had to have separate holidays on top of these field breaks. Now that dispute really centred on an interpretation of the working time regulations. And it wouldn't have mattered if a case like that was mediated, because no matter what the parties agreed between themselves, the law is the law, and ultimately only a judge can decide on the interpretation of that law. So it wouldn't actually necessarily resolve the dispute going forward, because it just is what it is. When mediation works the best is where we're talking about relationships. So we're looking at allegations of bullying, harassment. We've got people signed off for long periods of time with work-related stress, and it's because of a colleague. That sort of thing is really where the workplace mediation comes into its own, because it's not about deciding legal rights and wrongs. This is something I hear quite a lot. People say, in fact, there's one at the moment that's brewing. It hasn't matured into a mediation. I'm still discussing things with the organisation. But what they're telling me is that one of the parties, isn't really into this wishy-washy, mediation stuff. And I'm thinking, you might want to get them to give me a ring if they think this is going to be wishy-washy, because mediation really isn't the soft option. If you're at the point of raising a grievance beforehand, chances are you feel awkward about talking to them about whatever's troubling you. And so you suffer and suffer and suffer. And eventually you go to HR and they say, well, you know, we can't really do anything about it unless you make it formal and put it into a grievance. And then we'll investigate it, and then we'll be able to come up with an answer for you. And so what happens is that people are kind of forced into applying a label onto something like bullying, like discrimination. And it then becomes quite hands-off for them, because once they've got their letter in, all the work is then being done by HR. You're doing the investigation, you're setting up the meeting, you're doing all that kind of stuff. Whereas in the mediation, they have to come and sit down as human beings and talk about what's actually going wrong in the workplace. And that is not a soft option. I can tell you, everybody comes away from that absolutely exhausted, because it is hard. But then that's quite often why it.
Folks, we appear to have lost Lily. I'm hoping that she'll be able to rejoin us, obviously. Just keep an eye out for her. Oh, there she is.
Can you hear me now?
Yes, that's great, Lily.
Sorry, I don't know what happened there. The joys of remote.
Indeed.
Remote training. Where did we get to? Here we go. Okay, so we were talking about the what, and we've covered this. Where is interesting, I was speaking to Judith about this earlier, not the workplace. Unless you've got rooms that are completely separate where you're not going to have colleagues walking past, you need to maintain that neutrality. You need privacy. I've actually had a client pay a lot of money for mediation rooms in a conference centre, and when we got there, what we hadn't realised was the door and the walls of the rooms we were using were glass. And there were other companies there doing a conference, and so there was absolutely no privacy, and it was horrible. It really did not work. So the venue is actually quite important. It has to be a safe space. Another mediation that I did, the company booked a hotel. The hotel's meeting rooms were all taken up. They didn't know what we needed the room for, so they put us in the honeymoon suite for the mediation, and the girl had been alleging sexual harassment with her manager, and it was just awful sitting there. They'd put a table in the room, but there was a big 4-poster bed, and it was just so inappropriate. I could tell you stories all day. So venue is important. When? As soon as possible. The number of times I hear from people is, we're looking into mediation, but we want to finish the grievance process first. That is absolutely the wrong thing to do in an interpersonal dispute, because the grievance process itself is so damaging to the relationship that it makes the mediation, A, much more difficult, and B, much less likely to succeed. So if you do the mediation before the grievance, it doesn't mean you can't go back to doing the grievance if they don't come to an agreement during the mediation, or if something has been raised that needs to be investigated, like an allegation of something serious. But it's better, if they both want to go to mediation, to let them do that before the grievance hearing. If nothing else, it can narrow down the issues that need to go to the formal grievance, once we've stripped out the kind of background noise. Because I think most of you will agree that when somebody raises a grievance, quite often you just get a barrage, you get a 6-page document full of unconnected, confused things that they're complaining about. And the mediation can help strip that back and come back to you and say, well, this is now the only thing in dispute, and it makes the grievance a lot easier for you to deal with. Why are we doing mediation? Most of the time, people are doing it to tick the box. So they've been told by their employment lawyer, yeah, this is a really sticky one. It might go to tribunal. You want to at least show that you've tried mediation. And I don't mind that, because quite often when I do one of the tick the box ones, I end up with converts who actually see how the process has worked, and then something clicks and they get why mediation works in this particular situation. The other reason people want mediation is they really want to make it work. You know, maybe the parties are in dispute, but there's no good guys and bad guys in the real world. So the person who's been accused of being a difficult manager, or the person that's claiming that they're suffering in the workplace, they actually want to make it work. So that's the best possible reason to come to mediation. I also hear sometimes the parties say, yeah, well, I think this is a load of rubbish, but you know, I've been told I have to do it. And again, I don't mind those either, because once they see how it works, they do get engaged with it. So I don't mind how reluctant people are. Normally, it's the two people in dispute. I've also dealt with groups of people, and then we would need to chat and strategize about how that happens and when it happens. Sometimes someone will say, I'll do mediation, but I want to bring my union rep. And I would strongly, in most cases, discourage that. I would encourage it if it's an assisted negotiation. So if what we're talking about is mediating a settlement agreement to come to a figure, or mediating an employment tribunal dispute, absolutely, I've got no problem with trade unions or lawyers being there, not an issue. But when there's an interpersonal dispute, it's really not appropriate to have somebody like a trade union rep there. I'd rather they just brought a friend if they needed that support. But involving the trade unions can be counterproductive, because it's their nature to see it as a battle, and that's not what we're trying to create. So that's a bit of background. In terms of conflict, why do people end up in conflict? And if you think about it, every single one of us comes to work loaded with our own anxiety, problems, traumas. We've all got our emotional baggage that we are coming through that front door with. And everyone's baggage is different. Everyone's issues are different. That in itself is a disaster for, a recipe for disaster. Add on to that the fact that we all have different personality types. We all communicate different. Some of us over communicate, some of us under communicate, some of us are chatty, some of us are matter of fact, some of us go around the houses. Add that to the emotional baggage. And then on top of that, add the fact that people have got lives outside of work where things are happening to them. People are stressed out about COVID. People are stressed out about the Ukraine. They're watching the news. This is unconsciously adding to how they feel about life in general. And then add your background and everything else that's going on. And my goodness, it's amazing that we actually all even manage to function in a workplace together. All this chemistry with all these different factors, you are bound to come across difficulties. So what happens eventually is you get two people who are buzzing along with their different baggage, their different circumstances, different things that are happening to them. and there's a breakdown in communication. And that communication then starts to be destructive, because once you think somebody's bullying you, everything they say, you are more inclined to interpret as them attacking you or them bullying you. And by the same token, the person that's accused of bullying usually is coming to the mediation to say, well, this person's actually falling down in a number of areas with their work. And now I feel like I can't bring things up with them because anything I do is seen as bullying. And so we end up with a status quo. We end up with one or both of them signed off long-term with stress-related conditions. And then we say to them, you have to make this you have to tell us what's going on, and you have to make it formal. So what happens is people will then apply a label to what's happening. Instead of talking about the totality of what's going on, they will say, I am being bullied, or I am being discriminated against, which then turns into a process of dehumanization on both sides. So the person claiming to be bullied or treated badly will say, my boss is a bully. And labeling works, you know, we dehumanize people by saying they are a blank, whatever you want to call them. And that then makes it difficult for you to think of them badly and treat them badly in return. And once you have this, I'm the victim, or I'm the hero, or, you know, whatever label you want to attach to yourself and the other person, those positions become very entrenched. And when you come to a grievance, you've now got two sides of the battlefield where each side needs to win. They need to prove that what they're saying is true because they feel it's true. They're not making it up most of the time. Most of the time, they genuinely believe in their own position. So the grievance procedure is good for disputes relating to workplace processes, procedures, practices, things that are measurable and capable of being changed by HR. It's not so great where we're forcing labels onto people and we're giving that relationship situation a win-lose outcome, because it damages the relationship further. And if I can give you the example of family law, if any of you have been through a divorce or have friends that are going through a divorce or whatever, you'll see that what has happened over the years is there used to be big divorce battles in court over the kids and the house and everything, and they still do go on. But the legal system has really moved from litigation to what they call collaborative law. And family lawyers are almost acting in large measure like mediators, because they understand you need to, even if the people are splitting up, you need to preserve aspects of this relationship because they need to cooperate over children, or maybe they own a business together or property or something like that. So the law and formal processes do not work to allow that to happen. And I would argue that unfortunately, because we all got really excited when we joined the EU and we got all these new employment laws, we've all got a bit carried away with employment law and formal procedures. And we've kind of forgotten a little bit that relationships is what's happening in the workplace for the most part. And those have to be treated differently. So it's just adding another thing into your toolbox that you can use. So grievances mean someone has to initiate, someone has to launch the first attack. The other person's going to say, whoa, this label isn't me. I don't do that. That's no way. So, but I'm going to defend myself, and I'm also going to tell you why this other person is a disaster and why, you know, I'm justified in saying the things I say to them. So we've got this counter-attack. So somebody who's already fragile, thinking they're being or feeling that they're being bullied, is now having all these allegations made against them as well. And so it goes on. So they become entrenched, they focus on their positions and their labels. Nobody's really interested in getting to the bottom of what's going on because we're just focusing on the labels and proving or disproving, you know, whether bullying is happening, whether this is what's really going on. And someone's going to win and someone's going to lose. Even if you partially uphold some of it and don't uphold all of it, it's a win-lose outcome. So there's a loss of face, there's a loss of self-esteem, and there's a difficulty in getting back to work after this. And there's no real resolution. All you've done is got them to shut up for a little while and avoid each other. But the relationships are damaged, and it affects being able to work together in future. Because they're suffering, the organization suffers. It's the whole team. It's everybody in that department who's suffering because they're living with this. It's not just the two people who are affected. It goes beyond that. And what they have not done as part of that the grievance process, they haven't learned how to talk to each other and how to approach a difficulty if it arises in the future. So they're not learning how to solve their own issues. And this wee diagram really demonstrates what the goal is for a lot of these methods. So judging, or and that includes a grievance, because a grievance involves somebody sitting as a judge and giving a decision. So one person will win, one person will lose. That's just how the adversarial approach works. Negotiation means both parties giving up what they actually want to meet somewhere in the middle. So that's actually a lose-lose situation. The problem goes away, but each of them have had to give up substantially for it to go away. Where mediation tries to operate is in getting an outcome that's a win-win. So we're looking at the interests of both people.
Lily, can I just interrupt you before you go on? We've had a question from Emma, who's saying, have you got any tips for dealing with an employee who refuses to accept, or refuses to engage or accept responsibility?
For their behaviours, or?
I guess, but I don't actually know.
Yeah. I mean, if there's somebody that has made a complaint, then they can't really escape from it because it's going to be dealt with, and you can't force people to mediate. But if somebody's saying, I'm not doing that, I'm not behaving like that, that's not how I am, that's fair enough. But if the other person is raising an issue, there isn't really a choice but for them to look at it. I mean, it's difficult to answer that question without knowing the particular circumstances. But it is quite often that a person doesn't accept responsibility for who they are. Do we have any more detail on that? I can see there's more.
Just that it is, yes, behaviours.
Yes, behaviours. Okay. So sometimes people will not accept the value judgment that you've put on their behaviours. So this is quite a nice trick that I use in mediation, where often the behaviours you're pointing out to them are actually laden with values. So you'll say, you communicate in an aggressive style. People feel intimidated by you. And what they're latching on to is, you're calling me aggressive. You're calling me intimidating, and I'm not, I'm lovely. What you do in mediation is say, okay, well, this isn't necessarily about how you operate or what you're doing, but what you have to understand is that other person or other people's sensitivities. So because of the volume that you speak at, other people can interpret this as aggressive or whatever. So you are neutralizing the kind of words that you're using. And it does, when you first start doing mediation, you do find yourself kind of doing mental gymnastics, trying to think of other words and other ways of saying things. But you want to make them aware. It's kind of like in discrimination, where just because you meant it as a joke doesn't mean you're not liable, because it's how the other person receives it that also matters. So it's kind of like that, where don't focus on what they've actually said or how they're actually behaving, but try and get them to say, look at their behaviour as something that doesn't matter how you mean it or how you interpret it, speaking at a certain volume or speaking to people where you're giving them a critique in front of the whole team, that is interpreted by them as something that's aggressive. So that's what we want to look at, because we want to help you communicate more effectively without other people picking you up the wrong way. So it's a bit of a roundabout thing, but neutralize words. Think about how the person's hearing the words that you're saying and neutralize it. That would be my tip. So in the mediator's role, you're giving an independent perspective. So this is not like a sales pitch that you always have to come to somebody like me outside of it. I know that universities, for example, and councils train mediators in different parts of the organization, so that say there's a dispute in the legal faculty in the university, you can bring in one of the staff members that you've trained as a mediator from the medical faculty, who's completely separate from the people over here, and you can actually get that to work internally within an organization. So there's ways and means of doing it without necessarily employing somebody from the outside, assuming that your organization's of a certain size. But unfortunately, it's difficult to be independent if you are in that HR team of that company, because you're not truly independent and you won't truly be seen as independent by the parties. And it has to be confidential. And again, that can put you in a conflict of interest situation if you are in the HR department and you're hearing things as part of the mediation that potentially with an HR hat on, you would be doing something about it, but in a mediation hat, because it's confidential, you literally can't do anything about it. So that can be a tricky one. Listening skills are important. Exploration of the issues is important. So we're not forcing people to label. We're looking at what are you bringing to this? What is your baggage? What are your triggers? What's really happening here? What is that person really doing? And one thing I like to do with them is say, well, have you always gotten on like this? And 9 times out of 10, they'll say, no, we got on great. In fact, I had one set, which was a really bad dispute. They'd been going on holidays together in the past. Their families were close and the whole thing had gone absolutely skew-whiff. So it's useful to help them remember that time of how it was, so we can try and find out where things went wrong and help them work backwards from that. Unlike grievances, where if somebody starts crying, we give them a moment, maybe leave the room and avoid the emotions. In mediation, we actually let them go with it, because it's often that release then allows them to stop being so emotional about the issue and actually be a bit more practical to allow us to work with it. So allowing the emotions is really important. And we facilitate a creative solution. So we're not giving them a decision and we're not making one the winner and one the loser. We're helping them work together, helping them reality check what they're saying, helping them with figure out how we can implement any plans they come up with. And we're always going for win-win, and we're always not judging. Now, we are human. I always hear, oh, mediators have to be neutral and you're not allowed to judge anything. You do have in your head when you speak to people, that one's a bit dodgy, and you have your own thoughts and opinions, but the idea is that you don't bring that to the mediation. And I can guarantee you, if you ever start doing mediation, you will prove yourself wrong every single time. So you'll get a summary of the situation and your brain will start to do its employment law thing that, oh, that person's doing that and that person's doing that. Once you sit down and speak to them, you'll find out it's multiple shades of grey. There is no black and white in these situations. So we've got to keep fairness, control the discussion, don't let people go round and round in circles, remain impartial at all times. They will try and win you over. Every single time they will sit there and go, so you see what I'm saying? And they're trying to get you to nod, and you have to maintain that impartiality and say things like, well, I can see that this is really upsetting you. So you're acknowledging how they feel, but you're not actually taking sides. They make all the decisions. We get them to say what's bothered them in the past, but we're trying to focus them on the future. What does tomorrow look like? What does next week look like? And we're time managing, which I'm not doing very well at the moment, but that's what we're trying to do. I'm going to skip some of these slides because I think I've already covered the general gist of what I was saying in those slides. What does the mediation process actually look like? So I have honed my practice over the years. If you do mediation training, you'll be told you do private individual sessions with people, and then you do a joint mediation. Now, the way I was trained was that you did a mediation in a day. So one party would arrive 30 minutes before the other party, you speak with them individually, and then you have a joint session that lasts usually the whole afternoon to try and do it all in one day. Now, with years of experience, I can tell you that only works with an assisted negotiation. So that's fine if all we're doing is trying to settle a tribunal claim or come to a negotiation. With a relationship type mediation, I prefer to speak to each of the parties separately on separate days, usually by phone or Zoom or in a separate location, because then they don't feel pressured. They're not sitting there thinking that other person's in the next room. They might hear me. I need to hurry this along. You get their undivided attention. They get your undivided attention for that meeting. And what I find is that gets rid of a lot of that emotional buildup. They get that off their chest, and I can help them figure out how they're going to make their opening statements. And when we get to the joint meeting, I've got them down now to anything between 1 and 4 hours, because we've actually cleared up a lot of stuff in the individuals. Also, quite often in the individual sessions, I will find out that somebody will say, I really want to get out of here, but I can't afford to leave. And that gives me the opportunity to say, would you like me to confidentially approach HR and ask them if a settlement agreement would be an option for you? And they'll say, yeah, would you mind? I won't be giving up any of my rights. I'm a bit scared to do that. And I'll say to them, it's not an issue. I can ask the question. If it's something the company's happy to do, you can explore that option. And if it doesn't work and you want to come back to mediation, you can come back at a later date. So quite often it gives people an out at that stage without going through the whole palaver. The whole thing's so flexible. That's the beauty of it. It's not rigid and regimented like a grievance. So I help them come to an agreement, and this is just a summary of the individual meetings, which I've already explained. The joint meeting, I've already covered that as well. But in terms of how the parties are behaving throughout this process, we've had the individual sessions. I always try to think of mediation when I'm explaining it to people as a diamond shape. That's because I'm quite visual. So we start off with a nuclear explosion of whatever the issue is. And then when I deal with them separately, what I'm doing is I'm getting them to tell me everything. You know, I've had a case where one individual was saying, I'm being horribly bullied and all these things are going on and everybody's got it in for me. And talking with them individually, I found out that their child had a drug problem and had attempted suicide 3 times. Their partner was a gambler and they were about to lose their home. There was a whole bunch of stuff happening. And the only sanity this person had was their workplace. And when their performance was starting to slip because of everything they were dealing with at home, all of which they were not telling their line manager, by the way, because of privacy and feeling ashamed of what was happening to them. All the manager's seeing is somebody slacking off, you know, somebody not performing like they were before. But when we all got into a room and were, you know, able to expand a lot of these issues and have a proper conversation about it, they were able to turn the corner of the diamond where we've got all these issues, and then we start bringing it down to a focus, and the bottom focus is the agreement itself, where they start talking about how can we make this work for both of us, because you're a great employee, it's just that, you know, recently things haven't been great. What can we do to make this work? So you don't get that in a grievance. In a grievance, you're just going to get, he's a bully, and you're not going to really understand what's going on. So in the early stages, they're saying, you did this, and this is how I feel, and this is what's going on. In the solution stage, we're more getting to, what do we do about this? Let's get rid of the labels. Let's talk about what's actually happening. We're talking about the problem to start with, then we're exploring solutions. Grievances are about the past. They're not about today, they're about the past. Mediation hears the past, but then focuses on where we're going in the future. And at the start, they'll all look at me when they're talking, but when we get to the solution stages, they will now be talking to each other because they've gotten to that point in the dispute. The agreement itself, it can be in writing, but it's not essential. I encourage it because I cannot, through confidentiality, speak to HR about what happened and what the outcome was. I will encourage the parties to say, look, you might have a 2-page agreement here of what you've decided between yourselves, but what we now need to do is agree on something that you're happy for me to share with HR. Because if they've agreed that they're going to move the person's desk, or the person can start half an hour later on a Tuesday, or whatever they have agreed that affects the organisation that HR needs to know about, it's easier for me to be able to give you a document and say, this is what they've agreed that affects the organisation. We need to make sure that confidentiality is extended to allow that. So that was me talking as fast as I possibly could to try and get through all of this. You can tell, hopefully, that I'm very passionate about mediation. I'm passionate about the work I do as an employment lawyer as well, but it's about using the right tools for the right situations. And hopefully today I've given you some food for thought. I've given you some differentiation so that you can recognize what's appropriate and when. And I would encourage anyone at all times to get some skills training in mediation type skills, because they will help you in your day-to-day dealing with people, even if you're not doing actual mediation. Yes, you can get a copy of the slides. There's not much on them, it's mainly pictures. Does anyone have any questions? How do you deal with a poor performer who thinks it's not due to them? Again, it's about labels, and it's about statistics. How is their performance poor? Can it be quantified? Can you actually show them statistically what they're doing as compared to what other people are doing, and approach it as, what's going on? How can we help you? This is not about whether you think it's good enough or not. This is what we need from you. How can we help you get there? What's stopping you? What's impeding you? Is it training? Is it something that's happening? Let us know, because the performance we require from you isn't negotiable. But if we can do anything to help you get there, then we can work with that. So that would be what I would say. Thanks, Irene. I do actually, because I think since 1992, when we first joined the EU, and we all got horribly excited about employment law, and you know, going to lots of seminars and, you know, getting all our procedures and practices in place, we've become rather focused on the mechanics of it. And I think, although, you know, what I do really tends to come in at the really sticky end, I think if you have this as part of your core skills, you can head a lot of this off at the pass before it gets to the point where you need employment lawyers or formal mediators, because it's about retraining your brain to recognize what is an issue. You know, they're complaining about their bonuses, or they're complaining about the heat in the room. that's a grievance, absolutely. When it's interpersonal, if you could have some of these skills in your toolbox, you might be able to sort a lot of it out before it needs to be treated more formally. Oh, I'm glad. Any other questions?
Hazel saying, can you recommend training providers for this, as these relationship issues are really difficult to handle?
I mean, I did my initial training with core mediation, and I found that their training was really, really formal, and it was really sort of aimed at high level legal disputes. I then did a refresher training with the Mediation Partnership in Aberdeen, and they're not from a legal background, but they actually do in-house training as well. If you had a team of people you wanted to train, they do in-house training. But I found theirs was much more relationship focused and helpful. I'm glad I did both, but I think any form of mediation training, take it with a pinch of salt almost. You're being taught a set of skills, but you have to use your own mind to apply it. And I was taught very formally, like you do it all in one day, and after doing it for a few years, this crap, it doesn't work. It's upsetting everyone. It's putting a lot of pressure on everyone. And then I realized, oh, you don't have to follow all these rules. You can make it up yourself. So then I thought, I'm going to try and speak to people separately and see if that works. And it's great. It's really sort of speeded the whole thing up. And that's something I got from doing it with the Mediation Partnership, because that's how they do it. They tend to speak to people individually first. It's like, yeah, so it doesn't really matter who trains you, just don't take everything as gospel.
Yeah.
Bring your own personality to it and your own thoughts and feelings.
There's a good question coming from Isabel Lilly. She's saying, thanks Lily, very helpful. Additionally challenging when there are neurodiversity issues involved. Any recommended future resources or reading?
Do you know what? This kind of reflects how we approach things, because we want to go and read about stuff because we want to learn it, and we want to learn about toupee, and we want to learn about, you know, how to do all these different things. Because mediation is a technique, what you're being taught to do is facilitate people on their own terms. So I have actually dealt with people who have all manner of either disabilities or extreme personality differences. And it's really just about listening to them and figuring out what they need, because, you know, the neurodiversity is fine, but they can still tell you, this is what makes me uncomfortable. This is what makes me not be able to perform, because this is what makes me anxious. And then you can sit down and figure out, well, how can we manage this? How can we manage volume levels? How can we manage how we communicate with these people? Sometimes the answer is, if you want to tell me something lengthy, I'm not going to remember it all because I've got ADHD, put it down in an email. You know, it's can be as simple as some of these practical things. So you don't need to go away and do loads and loads of reading and try and learn about every possible situation that could come up. You need to go and learn the techniques of mediation so that you can apply it and you can deal with anyone.
Excellent, thank you. There's some comments coming in saying, thanks Lily, some really deep insights to reflect on further, especially around interpersonal conflicts and disputes. Great session. That's from Andrew. Rachel saying, thank you so much. You've helped sum it up so well and helped me to understand why it's so important.
Excellent.
And Isabel saying, thanks Lily, that's great. Yeah.
And when lots of you go and get the training, I would be really happy to have a mediation group that gets together and shares thoughts and ideas. And, you know, the more of us that there are, the better it is for everyone. So, yeah, go get some mediation training and stay enthusiastic about it, because it's a lot cheaper to be able to resolve these disputes yourself and help people be their best. Why should somebody just have to walk away with a settlement agreement feeling crap about themselves? if through this kind of process, you can actually enable people to operate as best they can and have some dignity. And if they do need to leave, to be able to leave with some dignity as well.
Yeah. No, you're right. It's the win-win, isn't it? You might actually have your first member for your group, Lily. I don't know what their first name is, but it's R right. And they've said, thank you, booked on mediation training on Monday. So this has been a fab intro.
Excellent. Good luck with that.
Yeah. I mean, really, I mean, you're so easy to listen to, Lily. And I think you just say it how it is, which I absolutely love. But I can't thank you enough for supporting the branch, coming along, giving us an insight, and hopefully inspiring some people to go and get the mediation training.
Hope so. That'd be good.
Yeah. But, thanks again for your time. Folks, thank you very much for joining us. It's almost 2 o'clock. I sadly have bathrooms to clean this afternoon, but I hope you can get out and enjoy the sunshine because it's still beautiful with me. I might actually just leave the bathrooms till later. They'll still be there later. But Lily, thank you so much. Thanks everyone for joining us, and hope to see you all soon.
Excellent. Bye, everyone.